All right, our final case this morning is Doug GUETZLOE versus Miguel ACEVEDO. And Mr. Mitnick, whenever you're ready to proceed.
I have a 5-minute warning.
Yes, sir.
May it please the court, Chief Mitnick for the appellant. We have a case that is of the most troubling kind of juror misconduct. We have evidence that a juror may very well have had a relationship with the defendant, with the party. We do not have a sour grapes fishing expedition after an outcome that someone was unhappy with in stumbling upon something. We have a frustrated juror who was on the panel frustrated with this juror, and that information made its way back to trial counsel. And the information was very troubling. Rather than, at the very least, it called for questioning the jurors to get to the bottom of this serious piece of evidence.
Well, let's break it down. It seems to me, if I'm looking at the affidavit that you filed, that there are three complaints. Two kind of fall into one category and one into another. The first two complaints are that allegedly the reporting juror became concerned because the alleged juror that was engaged in misconduct seemed protective of the defendant doctor and what an adverse ruling would do to his reputation. So we got she seems protective and concerned about the defendant's reputation. That's concern number one.
Yes, sir.
Concern number two is the alleged statement by the juror that the plaintiff was a, quote, rich Republican lobbyist, end quote.
Yes, sir.
And then we have the third, which I think falls into a little bit different category, about did she fail to reveal that her boyfriend knew the defendant doctor.
Yes, sir.
All right, let's deal with the first two.
All right.
All right. Why aren't those just the sorts of things that inhere in the verdict and just the sorts of normal conversations that jurors have?
Well, they may be, but they're not supposed to be. And I think the truth is it probably does happen and we never hear about it. I don't know that, but I suspect it. But there's clearly instructed not to do that. You're not supposed to be swayed in the performance of your duty by any prejudice or bias. And to say he's a rich Republican lobbyist and this will hurt the doctor's profession are totally impermissible considerations, and they fall clearly with an instruction of the court. And that same situation was dealt with in the Singletary case, in which they said, aside from not honestly answering the questions, that court really did what you're doing, Your Honor, which is segregating the questions into categories. And aside from not honestly answering questions, these are issues of prejudice, that you were being swayed in the performance of your duty, and that's a direct violation of the court order. And in that case, reversed as a result of it. When they were
But Singletary dealt with overt acts of racial prejudice. Is that not correct?
Well, it dealt with someone who said they knew the family and said they should be sewn up and not have any more babies. So,
And this was a black plaintiff and a white jury.
it is.
And there was allegations. I think the court's concern there was that there, the concern was one of racial prejudice, and saying things like that in the jury room indicated racial prejudice. Well, let me ask you, let's talk about the rich Republican statement. Is that a pejorative? I mean, I thought there was a lot of people that aspired to be both rich and Republican.
Well,
I guess the question is, I'm not sure how that's a pejorative.
I think it's just as pejorative as someone saying he's a screaming liberal, and someone may take that as a compliment, but if the person who clearly says it in the negative, it is a negative. And in this case, in this context, I think any read other than it was meant as a pejorative is a stretch.
Let's assume that was said. I mean, is it improper, for example, for a juror to say during deliberations, I think the witness was a liar? I mean, that's pretty pejorative, but isn't that...
Very pejorative, and if there's evidence to support it, it's an absolute proper consideration. In fact, if they didn't consider it, if there was evidence, they'd be violating the court's instructions on believability. But the distinction here is we're dealing with a clear-cut instruction from the court that says that's not a fair consideration. You should not be swaying the performance of your duty because he's a rich Republican conservative.
Well, Mr. Mednick, what are the limitations on the post-trial viewing of comments by jurors?
I'm not clear what you're asking.
What rules apply to us looking back at comments made in the jury room?
Well, the rule is this, as I understand it. They really kind of fall into naturally in combing through these cases 3 categories. One category, which we haven't reached yet, is the category where you have someone who concealed something before that.
So you can certainly inquire into whether someone is concealed.
The other category is where there appears to be a violation of a court instruction or evidence of prejudice or bias. This actually...
2 or 1?
It's actually 2, and I'll give you an example. In here it's lumped into 1 because they're the same thing here, because they violated the rule not to be swayed by prejudice or bias. However, it is broken down in the courts separately. In fact, one of those cases is a 5th District Court of Appeals case, the Snook case, in which the instruction that was violated wasn't racial, it wasn't something negative like you're a rich Republican. It was simply they discussed the case before deliberations. And this court said you violated a court order and reversed. So that's a whole separate category. But I would like to say one thing, if I may.
Okay, yeah, and then I want to go back to another question.
Very briefly. I'm happy if the court wants to break it into pieces. It just makes me, and you're the boss on that, but I want to remind you that this isn't done in pieces. I got a lady who made a fellow juror, uncomfortable with how defensive she was of the doctor, and in the same breath was taking a back slap at the plaintiff, and in the same breath find out that her boyfriend is friends or has a relationship of some kind with the defendant that wasn't revealed. So the totality, I think if we're going to look at them separately, we have to look at them through the lens of the totality of the circumstances.
Let me flip the question around now and ask you, what sort of things are we not permitted to look into? What sort of deliberations are we not permitted to look into?
You know, honestly, Judge, I saw those opinions, and there were a bunch of them that talked about, and I think they cited some of them in their brief. I ignored them because I didn't think they applied here. But there certainly is a body of law there that defines you're not supposed to go into these. There's even a statement that you're not supposed to go into just the method of deliberation, but that it was an unfair system that led up to it. So there is some definition in the cases that they cite as to what you can't look at, and what really is just too much picking at it afterwards.
Well, you see, what I'm looking for is to see what the 2 limitations are, what we can look into, what we can't look into, and see where these fall.
Maybe I'll save some of that for my 5-minute rebuttal after I hear him. I
think that's fair.
Focus on it, and I can't answer
fair.
that part. In any event, if I may move then on past the first comment, which candidly, if it was in and of itself that comment I'd heard, I probably would have hesitated over whether to appeal over just the one comment.
You agree that, I was reading a case out of the 4th District, Trevent versus Schechter, where apparently, I guess the plaintiff was a lawyer, and the allegation was made that during jury deliberations, a juror said something to the effect of, I would never give money to a rich lawyer, or I'm not going to give money to this rich lawyer, something to that effect. And they said, not good enough.
I'm surprised, but if that's the ruling, that's the ruling, and that's precedent. But it doesn't change. We have to look at it through the lens of a fellow juror who says there's something odd enough here in her behavior. Remember, the verdict actually was for the plaintiff. The other jurors were for. We have one juror who's acting odd. It also has to be looked at through the circumstances that's part of the record on appeal. This same juror had a malpractice case from her grandmother where she said, I thought my grandmother's leg got amputated because of the doctor's malpractice, and because of the malpractice suit, I harbor ill will against the defense side in this case. Yet, she is, contrary to the other five jurors, advocating so strongly that one of the jurors grows suspicious and inquires of her. Now, through that context, we have someone who says she's concerned about protecting this doctor's profession, which is absolutely an inappropriate consideration, takes a nasty backslap at the plaintiff, and says her boyfriend knows the defendant. The totality of those circumstances, it is, I always hate to use big adjectives, but I can't imagine that doesn't call, if we're serious about justice, at least inquiry. Don't we get the people in and say, what is this about? Don't we get the people and say, well, what kind of relationships your boyfriend have? Do you have one too? Are you friends? Are you business associates? And there's no way.
Of course, those were all questions that could have been asked that weren't, right? I mean, one of my concerns is you have to, in your brief, weave an argument that says, well, this question was asked. We didn't really ask it, and I think the question that was asked was very vague and ambiguous. But when you look at everything, a reasonable juror should have known that they ought to reveal something that they weren't specifically asked about. And my response to that is, if it's important to you, why don't you just flat ask it? You had plenty of opportunity. You could have just asked, do any of you know this doctor? Does anybody in your circle know this doctor? You didn't ask those things.
Here's what was asked, and I would cite on that point to the precedent out of the Singletary case, which dealt with just that kind of an argument. And the Singletary case said, while Singletary's attorney did not specifically ask whether any of the panel knew the Singletary family, it is abundantly clear, as it was in Mobile Chemical Company, that no person sufficiently perceptive and alert to be qualified to act as a juror could have sat through the voir dire without realizing that it was his or her duty to make known to the parties in the court any relationship with any named party, witness, or attorney, or the immediate families of the parties. That's that same argument. Now, we're talking about a juror who was asked these things. I don't, with all due respect, I don't agree that I'm just pussyfooting around and I didn't really ask it. I asked, number one, the judge said, do you know this man? First of all, that ought to be, well, my boyfriend does. And, I mean, in this same spirit of Singletary, how do you honestly go, no, I won't tell him about my boyfriend. That doesn't fall within the spirit. But we didn't stop there. Next, I inquired specifically, does anybody here or their inner circle, and I defined inner circle as you, friends, family members, clearly includes a boyfriend, have any relationship or any connection, that was the word, any connection with health care providers?
What is that? Do you know a doctor? Do any of your friends know a doctor? Wouldn't that be a relationship with a health care provider?
Absolutely.
And you wanted them to tell you if they knew a doctor, or their friends knew a doctor? Not the doctor in this case, just any doctor?
I not only wanted to know if you do, I wanted to know if your family does or a friend does, because my follow-up question is, how close is that relationship?
So let me ask you this. So you're a prospective juror, and I ask you, do you or any of your inner circle, and I grant you that'll include your boyfriend, do you or anyone in your inner circle have any connection with health care? And your view is that question requires me to tell you both every doctor I know, and to my knowledge, every doctor that anyone in my inner circle, which presumably is my wife, my kids, my mom, my dad, my brothers and sisters, and really close friends, every doctor that they know.
If you're there at the dinner, nobody was, I don't remember if it came up in this one or not, I have to look at the transcript, but oftentimes someone will say, do you mean, by that question, do I go to a doctor, and I have a doctor I go to? And I'll say, no, that's not what I mean. Do you have some kind of relationship other than you just go to the doctor, unless you particularly feel a kinship to him because he's been such a wonderful doctor? I don't know whether that dialogue happened, but it happens all the time. And I have juror after juror raise their hand to that question. Well, my sister is a nurse. Well, my husband's best friend's a doctor. I get it all, and it happened in that panel. If you look at the transcript, I had person after person raise their hand and come clean with it. And I got a juror, not just generally to health care, who's already on pass one from the court, not said, I have a relationship with my boyfriend, has a relationship with that defendant. Didn't answer that question. When asked any relationship, including your boyfriend, with health care, your question seemed to be, gosh, that's such a broad question. It would include really simple relationships. Okay, but how does that excuse her for not responding to a gross relationship? That I don't understand the logic to say if it's a broad question that would include even minute things, but that somehow is an excuse for her not telling a direct relationship. And then again, at the end, after me going on for hours and hours in voir dire, making it perfectly clear that anything that would give even the appearance of leaning towards the side. If you look at the transcript, I go over and over, in spite of your best effort, any leaning whatsoever, anything would appear to have a leaning. Never does it come out. And then at the end, I give her one last chance with a catch-all to people. Is there anything? You've heard the things I'm concerned about. You've heard of any kind of relationship, any concern. Anything may appear that way. Is there anything else, any of you, we haven't touched that I've missed? I don't want to just have not asked the question right. Now's the time. Please tell me. Now, assume her boyfriend is friends with the defendant. How does she not answer that question? And we don't even get to question about it. Not even an interview.
One possible explanation is she didn't know.
But if you look at the case law, it says if there may have been. And there are italics around may that this court put in an opinion taking the rule. If there may have been, we certainly tendered up evidence that there may have been. I might get to the interview and find out. I didn't have a clue. And I might go nowhere. But how do I get shut down from even inquiring and we just say, let's walk away, not even look into this? I just don't see how fundamental fairness allows that, particularly when you, and this is my last comment before I sit down, out of the Minnis case, which laid it out perfectly. This is what we're faced with. And in the Minnis case, it said the right of counsel to challenge a juror for cause or peremptorily being indispensable to the successful operation of a jury system. The right of fair trial by an impartial juror is destroyed when the right to make an intelligent judgment as to whether a juror should be challenged is lost or unduly impaired. When this occurred, the verdict should be set aside and a new trial granted. I just want, while I moved from this trial too, I primarily wanted to question these people. Thank you.
Thank you, sir.
Thank you. Judges, I have a bit of a cold, so I apologize occasionally, and I get choked up, but I've just been having difficulties. Brian Stokes on behalf of the appellee. Preliminarily, I think a question that needs to be addressed here is what is the standard of review? The appellant has argued that he gets what I guess he perceives to be a more favorable standard of review, that is of de novo, because the trial judge isn't the judge that ruled, the judge that presided at trial is not the judge that ruled on his motion for interview and motion for new trial. And I submit to you that he's waived that argument by the fact that he never on the record requested that Judge Coleman, who presided at the trial, actually rule on this motion. And
how can you waive a standard of review?
Well,
that's not something.
Yeah, waiver relates to preservation.
No, I apologize if I misstated it. What I'm saying is he's trying to say I wanted Judge Coleman to rule on the issue. Judge Thorpe ruled on it, and because Judge Thorpe didn't preside over the trial, this court should therefore apply the de novo standard. What I'm saying is, to the extent that because a different judge ruled on his motion, you would get a different standard of review. He waived his argument on the underlying basis because he never said to Judge Thorpe on the record, I don't think you should be deciding this. This should go to Judge Coleman. What I'm suggesting to the court is that based on what happened in the lower court, we should be applying the abuse of discretion standard of review, not the de novo standard.
I agree with you that when you examine the case law, including the case law out of our court, they generally say without any particular analysis that the granting or the denial of a motion for a jury interview is within the discretion of the court. I'm wondering, though, I mean, I do think there's some logic in the argument. I mean, normally discretionary calls are we have a deferential standard because the judge is in a better position to kind of eyeball what's going on. I mean, this judge, I don't know whoever ruled on this,
Judge Thorpe.
she wasn't in any better position than anyone else given the transition. But more importantly, I'm looking at the standard that the Supreme Court came up with in Baptist Hospital versus Mailer, and they tried to articulate the test about when you can and when you can't get a jury interview. And what they said in that case was, we hold that an inquiry is never permissible unless the moving party has made sworn factual allegations that, if true, would require a trial court to order a new trial under the standard adopted in Hamilton. And what that says to me is, in making the threshold decision of do you get to make an inquiry or not, the trial judge looks at the sworn allegations of the motion for an inquiry and says, if they can prove this, they get a new trial. That's the standard. Do you agree that that's what the Supreme Court says?
Sir, I agree that that's what.
Why isn't that so the trial judge is required to assume under the standard that I just read to you, that whatever they've put in their affidavit is true, right?
Okay, I'm following with you so far.
So if that's the case, why isn't it a de novo standard in the sense that just like a motion to dismiss or a contract review, I mean, if we're confined to looking at strictly the document, the affidavit that they've filed, and that's all the trial judge can look at, why should we defer to the trial judge's better vantage point or fact-finding ability when there was no fact-finding and there was no better vantage point, because the Baptist Hospital case says, look at the affidavit and say, if that's true, I got to give them a new trial.
Well, I'm not sure I know the answer to that, except that I know that as you started out your question, courts have time after time after time said the standard we're going to apply in this context is the abuse of discretion standpoint.
The interesting thing is when you go back and read those cases, the time and time, and I haven't gone back to, Blackstone's commentaries, but I can't find one that really gives it much analysis. They just say the same thing and move on.
And I agree with you, and I guess the response I would make is why, given the history of case law, when the courts have repeatedly said it's the abuse of discretion standpoint, why would you get a different standard of review in this case because there were different judges involved, particularly when you didn't complain?
Well, I'm not focusing on the different judge issue. I'm focusing on the test that the Supreme Court said that the moving party doesn't get an inquiry unless the sworn factual allegations, if true, would justify a new trial. So why isn't that the same as when we review it? If you bump this complaint out on a motion to dismiss and it comes up here on review, we look at the four corners of the document just like the trial judge does. We don't give any deference to the trial judge because it's purely a matter of law. Why doesn't the same thing happen in this case when we're supposed to look at that affidavit and say, if he can prove these things, he gets a new trial or he doesn't?
Judge, I come back to even since the Baptist case, the courts have continued to say it's abuse of discretion. I don't want to use all my time on that point because I do think that whether you apply the abuse of discretion standpoint or the de novo, we still get to the same result, which is that the trial judge was correct. A point that has been omitted from the oral argument so far has been the process by which the information that went into the affidavit was gathered. As I point out in my brief, I think that there has been a violation of both the rule of civil procedure as well as the ethical rule.
Well, the fact that, excuse me, the fact that Mr. O'Neill had represented Mr. Getzloe in a number of cases, and I don't think there's, from what you say in here, there's apparently plenty of evidence to suggest that Mr. O'Neill has represented him before. I mean, what the rule says that no lawyer connected with the case, this case.
That's the ethical rule. The rule of civil procedure says a party shall not. It doesn't limit itself to lawyers. And I think that what the rule of civil procedure is trying to say is no one on behalf of a party can initiate the contact that forms the basis of a motion unless you go through the process of asking, of submitting all this information, and filing the motion and requesting the opportunity. So I think under the rule, and that's what happened in Solomon, the court said the lawyer, admittedly, who had appeared in the case, who had represented the plaintiff in the case, they said she was acting, she violated the rule when she, on behalf of her client, went and initiated contact with jurors. In this case, there can be no question but that Mr. O'Neill was acting on behalf of his client when he said to the brother, let me call Mr. Petrusik, or have Mr. Petrusik call me, and let me then talk to him directly without filing a motion, without giving notice, without
But you say there can be no question, but there's no record evidence to suggest whether he just sort of did this on his own or whether he was acting as a proxy or an agent of Mr. Getzloe. I mean, you're suggesting that if you had a prior relationship with a client, that anything that you do thereafter that might somehow incidentally benefit that client is done on behalf of the client.
This isn't a prior relationship, Judge. This is an ongoing relationship, as the materials in the appendix, as the records in this court will reflect. Mr. O'Neill has in the past represented Mr. Getzloe and continues to represent Mr. Getzloe in a wide variety of things. So I think it's.
But didn't the juror initiate this conversation?
The way it worked was Mr. Petrusik, the juror who Mr. Mitnick describes as being concerned, spoke with Mr. O'Neill's brother.
Okay.
But then Mr. O'Neill's brother called the lawyer O'Neill, who then initiated the contact with the juror. In other words, what should have happened here, candidly, would be for an affidavit for the brother to have been filed, and then the procedure could have been complied with. But Mr. O'Neill did an end run around the rule of civil procedure, as well as doing an end run around the ethical rule.
Mr. Stokes, I think we all understand that argument. I don't want you to get too far into this without getting to the merits.
Yes, sir.
That's really where we want to focus.
Yes, sir. Well, I think the court has hit it on the head in a number of respects with respect to their questioning. First, there's no showing that Mrs. Maloney failed to truthfully answer the questions and was put there. As I think Judge Palmer pointed out, we don't know that she knew at the time the question was posed that her boyfriend knew the defendant. And Mr. Mitnick has used the phrase friends and relationships. There is absolutely no showing that the boyfriend, let alone Mrs. Maloney, there's nothing in the record that they had any relationship, friendship, that it was anything other than, yeah, I know the name Dr. ACEVEDO. That's all we know if we accept their allegations as true. So I think we get to the point there's not been a prima facie case showing that they should have been entitled to an interview, because just knowing a defendant doesn't disqualify someone from jury service. In fact, as I point out in my brief, I argued that a juror should be disqualified because she used to work for Mr. Getzloe, that should be cause, and Mr. Mitnick opposed me, saying, no, that in and of itself isn't enough to disqualify her when she says that she can sit fairly and impartially. And ultimately, Mrs. Maloney said under questioning from me, I can sit fairly and impartially in this case. We also have to go to the issue is, well, would that material means that had Mr. Mitnick known that answer, that he would have then likely exercised a peremptory challenge? And candidly, I don't even remember if he had any left over by the time we got to Mrs. Maloney. But assuming we did for a minute, keep in mind that Mrs. Maloney also said to Mr. Mitnick, I may hold you to a higher standard of care, or a higher burden of proof, than the law tells me I am to apply, because you are potentially impacting on this man's livelihood, this man's professional reputation. And so, Mr. Mitnick, if your question is, might I require more of you than what Judge Coleman's going to tell me is going to be required of you? The answer to that question is yes, I may. And yet, he didn't exercise a peremptory on her. I need to, I think, also respond to the comments that's been repeated in the briefs as well as somewhat today about, well, why didn't I move to disqualify her, given her that she had indicated an unfavorable impression of doctors based on her grandmother's experience. I can tell you that I liked her answer to that. I may hold you to a higher standard, and made a judgment that I wanted to keep her on if I could in light of that answer. Additionally, I made a strategic decision because one of the plaintiff's experts was going to be attending by videotape, and we did not want to continue this with the trial, to see what we could do to get a jury out of this case. So I made a calculated decision based on the entirety of the facts to leave Ms. Maloney on the jury, even though she had said she wasn't particularly enamored by doctors. The other element, though, that Mr. Mitnick has to establish, and I think Judge Palmer, you hit it on the head as you were asking your question, is that the failure to disclose under Tejada and the other cases, the failure to disclose can't be the result of lack of diligence on the part of the inquiring lawyer. And as you point out, it is a rambling, long-winded, as I point out in my brief, question that touches on a number of topics, a number of industries, and then amazingly says, let's start out with Florida Hospital. As if to say, after I've given you this broad scope and universe, let's narrow it first down to Florida Hospital, who used to be a defendant in the case. And then the next question that should have been asked, but apparently never was, as I read it, was, okay, now that we've covered Florida Hospital, let me ask that same very broad question and narrow it down to Dr. Acevedo. And that question wasn't asked. And so there's no showing, number one, that she concealed, number two, that it's material, and number three, that it's not the result of diligence. Finally, with respect to the issue of emotion, Mr. Mitnick is really asking the trial court and this court to allow him to question the jurors about how they reached a verdict. And he made the comment, 5 of the jurors were with us. I don't know that he knows that. I don't know how he knows that, because none of us were back there. So to say that this is the one juror who seemed to turn the tide against the other 5, there's no record evidence of that. In fact, the verdict would seem to suggest that there was a wide range of opinions about Mr. GUETZLOE and the merits of his case and the damages that he sustained based on the verdict that was returned. But I think I've cited it in my brief. The Tikaris versus Julian case said that allegations that a party or that a juror was motivated by feelings of sympathy is insufficient to support a jury interview. Yet that's what Mr. Mitnick wants you to do. I think the other point, and it was Judge Orfinger that commented on it, is the comments that were made with respect to, well, first off, at some point, I know Mr. Mitnick has said in this case, sympathy should have no role. I find it interesting that plaintiffs in personal injury cases spend a lot of time, it seems to me, invoking sympathy in an effort to drive up damages, but now when it may have come back to bite them, they want to say, oh, no, there shouldn't be any sympathy. But that ignores the reality that at some point, as jurors decide a case, they have to pick a side. They have to pick a side. They have to have decided, I'm in favor of this side and against that side at some point. Otherwise, we never get a verdict. So they have to be moved somehow to one side or the other in a courtroom. So to say, well, sympathy should absolutely have zero role, I think ignores the realities that there has to be movement to one side, and one of the ways may be a perception of the evidence. Judge Orfinger, you hit it on the head citing the Trevent case, where if the comment was made, it is nothing more than a comment based on the perception of the evidence that the jury heard. And that's certainly appropriate for them to draw a conclusion to say, you know, I think the plaintiff is a rich Republican lobbyist, and therefore his damages aren't as bad as he thinks, as he would have us believe. It's no more different than a juror saying, you know, I didn't buy what that expert witness had to say because he's paid to say what he said. That's what conclusions jurors reach based on hearing the evidence. Mr. Mitnick cited you to the Snook case as if to suggest, well, because the jurors spoke among themselves in violation of the court's order, that somehow entitles him to a new trial and reversal. He leaves out, though, that the Snook case, the jurors went beyond that. One juror actually undertook his own investigation, went to the store where the tire had been bought, purchased the tire, had interaction, and then came back and used that evidence that had been gathered outside the scope of the trial to suggest to the jury that this is how the verdict should turn out. In conclusion, unless there are some further questions from the panel, I submit to you that whether you apply abuse of discretion or de novo, Judge Thorpe was correct in her ruling to deny the motion for interview, was correct to deny the motion for new trial, and would ask that this court affirm the lower court's ruling.
Thank you, counsel.
I agree it should be de novo for the reasons you said, and additionally, I asked specifically to have Judge Coleman to the judge's JA. She went and talked specifically to Judge Thorpe and came back and said, absolutely not. So she shouldn't have been hearing it. She did. She shouldn't get that burden, that extra burden, and for the reasons Your Honor said. On the other issues, just to boil it down, based on that standard that Your Honor has pointed out from the Supreme Court, the question is, do you get a new trial based on what the affidavit says or where it reasonably could lead? Of course, you don't. You got the affidavit that doesn't have an inquiry in depth like you would in an interview. But with the reasonable assumptions of where that interview process could have gone, not wild way out, but where the likely reasonable place you would go from the information that is in the record in a sworn affidavit. We're looking at a situation where you say, well, if it was true that this lady, boyfriend, has a relationship with the defendant in this case, and let's say that relationship is a friendship, some meaningful relationship, does that grant a new trial? On that one line, I submit absolutely. Was it not covered by a question? Albeit Your Honors may think it is a vague question, the record is very clear. There's speculation that, well, people could have been confused and people may have misunderstood and they may have thought he was only... The record on its face shows the question was asked point blank, if you have any connections at all or friends, including boyfriends, with any health care provider, and if her boyfriend is in a relationship with this defendant, she was required to reveal that to me, particularly on the heels of the judge asking, do you know the defendant? That's a you, but your boyfriend does, that's skirting the truth. And then with a catch-all after it being clear, if there's anything we need an openness that would even indicate a potential for a bias, please tell me anything, ma'am, and you still concede it. Clearly, if she had a relationship under that standard of the Supreme Court, that dictates an interview because it leads to a new trial, if indeed that relationship was meaningful. And I don't have any opportunity to find out what the depth of the relationship at this point. She didn't reveal it to me to ask it in voir dire. I found out about it from a fellow juror, number one. Number two, the next issue, aside from that, which has nothing to do with the questions that I asked, is would we be entitled to a new trial based on the affidavit if, in fact, the court found that she was swayed in the performance of her duty because of a sympathy for the defendant that it would affect him professionally. That is absolutely not an appropriate concern. And for her to be voicing it in deliberations, we can't say because it may happen and we don't know about it, we're going to now permit prejudice or sympathy to sway people. We're going to just let that rule not matter because it might,
Wasn't there something like that in the Baptist hospital case where they said, you know, we gotta do something to help this poor little child, or something like that? Well, counsel, you've exhausted your time. Thank you so much for the arguments, and you all have a safe trip home. Thank you. We'll be in recess.